And then I'll dwell on something which many of you would want to know about, which is about the use of technology. Since the early 1990s, we've been using computers in courts. First, we used them as substitutes for typewriters, then gradually to collate data that we fed into the system to produce cause lists. Then we fed data on court websites. We graduated to online filing and paperless courts in Delhi in 2010. Since 2013, we have the National Judicial Data Grid. It's a promising start in making judicial data concerning the district courts accessible in granular form. The e-court project, in the meanwhile, has entered its third phase with a budgetary outlay of over 7,000 crores. And this is something I wish to emphasize. There is no shortage of money for judicial reform. Very often, the judiciary is returning monies unspent, whether for digitization, court infrastructure, or even legal aid. The problem then is to learn how to spend it. COVID-19 brought in a sea change in how courts at all levels functioned. Online hearings, e-filings, scanned files, use of digital devices, live transmission of court proceedings became almost routine. Much of this has continued since then, although it still meets with some resistance from a section of lawyers and the court staff. All across the country, however, the e-courts project is not progressing as well as it should. There are several reasons. First, there is still a digital divide amongst lawyers. Not all of them can afford the smart devices like iPads. Then there is a reluctance on the part of some of the judges, lawyers, and staff to adapt to the changed style of working. There is uncertainty still in many courts of the country of uninterrupted power supply and network connectivity. And above all is the centralization of the management of the digitization project with the e-committee of the Supreme Court. The insistence by some courts that lawyers should, apart from e-filing the case, also supply hard copies of the paper book is a disincentive. By now, we should have had paperless courts at all levels of the judiciary, digitalized all court records, past and present. We could have had a dedicated cadre exclusive to the judiciary for technical support services. This transformation is even now possible. This is the only way forward if our courts have to stop being paper guzzlers with overflowing records spilling over every available floor space. You know, this calling for the records not being found in court, cases getting adjourned for that reason is an endemic problem. And very often a lawyer will simply stand up in court and tell the judge, please call for the record, which means if it's the record of a court against whose decision appeal is being filed, that court will not continue to deal with the case. So we have had this instance, and this is a real instance, of this judge in the Delhi High Court. He was a very, very patient judge and doesn't show too much reaction while the case is being argued, and is known to be measured in his response. So the case was called out. It was a case of prayer for grant of an interim injunction. So naturally, the lawyer was very anxious. So the minute the case was called out, the lawyer took off. And he's a senior lawyer, went on non-stop for about 20 minutes till the instructing lawyer pulled the gown and said, no, let's find out what's happening on the other side. So when there was a pause, the judge turned to the stenographer and said, Likhiye, file not received, re-notify on. Basically, the judge was not even, telling the lawyer, because he was supposed to be a patient judge and he didn't want to interrupt the lawyer. And it left the lawyer completely clueless as to what to do. So this problem of records being stuck in our courts is something that can easily be overcome if we resort to digitalization of our court records. It will free up space in the court and it will help, cases move faster. There are several reasons why many of these measures have not worked. First, our entire legal system revolves around the convenience of lawyers, judges, and the state. They're not litigant-centric. Even today, it is not possible for a litigant to navigate the legal maze without professional legal help. The entire legal system, which includes the judiciary, is only catering to their own convenience, and every attempt at legal reform without inputs from the actual users of the system is bound to fail. The harsh truth is that the system of judicial administration in these 79 years has not been as democratic and accountable to its users as it ought to be. A vision of the legal system of 2047 would be the completion of the unfinished task of what we call process reengineering. We have so many meaningless forms and registers to fill, forms of address of petitions, and all of this should change. This should happen with the help of technology. By 2047, we should have completed this task, and this should be based on hard data. This time it must happen in an open, transparent manner and in consultation with the users of the system. Second reason why these reforms fail is that we are not a society that is attuned to accepting a rule of law paradigm. The complete internalization of constitutional values at a personal and societal level is yet to take place. Social democracy, as envisioned by the constitution makers, is still a work in progress. Baba Saheb Ambedkar's prophecy of our country entering into a life of contradictions on 26 January 1950 should hopefully not hold true for 26 January 2050. A cause for concern is that even after 79 years of independence, those in power continue to betray Ambedkar's vision of constitutional morality. Today's citizen is very often alarmed to find that those in power themselves do not adhere to the rule of law. The prospect of state anarchy is precisely why we have a constitution. Its primary purpose is to place checks on the abuse of state power. The judiciary's track record in delivering on the constitutional promise of being a bulwark between the people and the anarchic state has at best been inconsistent and quite often disappointing. The attempts at creating a false equivalence between fundamental rights and fundamental duties misses the point about the obvious imbalance between the mighty powerful state that monopolizes the use of force and a citizen seeking the protection and enforcement of the basic survival rights to life and human dignity. Third, and this reason is important, our lawmaking processes are by and large top-down. The people likely to be impacted are seldom consulted. The language of the law makes it difficult to comprehend. Very often, laws are passed without any meaningful debate or discussion by our members of parliament. When one regime is successful in bringing laws using the bottom-up approach, like the Right to Information Act or the Land Acquisition Reforms Act of 2013, of the Food Security Act or the Forest Rights Act or the Manrega, the succeeding regime will work to undermine it, dilute it, and make it ineffective. Where the attempt is to bring about social transformation through law, the process of top-down lawmaking easily alienates the people. Naturally, they're reluctant to accept as a binding norm of social behavior. This explains the failures of the Dowry Prohibition Act, the Child Marriage Restraint Act, the Bonded Labor Act, the Child Labor Act, and other similar enactments. Courts can do little to persuade acceptance of laws by the people. It is often saddled with the consequences of their failure. The fourth reason is this. Governments and legislatures have failed to seriously take the concept of judicial impact assessment, on which two expert committees have submitted reports. Every change in an existing legislation and every new enactment has the propensity of increasing the work of the courts manifold. The 1988 amendment to the Negotiable Instruments Act that criminalized as an offense the bouncing of checks increased the workload of our magistrates' courts hugely. As of today, we have 40 lakh check bouncing cases that make up nearly 40% of the total pendency of criminal cases. Therefore, decriminalizing the offense of check bouncing and restoring the status quo is actually no-brainer. Fifthly, all reform in our pyramidal structure has to start at the top. The initiative has to come from the Chief Justice of a High Court or the Chief Justice of India. If we are going to have persons in these positions, not even for a few months, and sometimes it is for a few days, then the kind of reforms one needs for complete overhaul will simply not happen. If the CJI shows interest in accelerating the pace of digitization uniformly across all courts, it is likely to happen. The next best thing to do is to learn to delegate, broad-base the system of judicial administration, have a continuous monitoring of the implementation of the numerous reports that have already been submitted and are waiting to be acted upon. Both the E-Committee and the NCMS should not be the sole preserve of the senior-most judges of the Supreme Court. It should have judges lower in the pecking order, judges from the high courts who are likely to remain in the system for 10 years or more, and a fair representation of domain experts that can help steer the reform implementation process. The process must be consultative. It cannot just be a three-way dialogue between the bar, the bench, and the government. The judiciary must take the initiative to organize the conduct of surveys to find out what the users of the system need and would want to change. Our reforms have to be litigant-centric.